With American democracy on the precipice, Americans are witnessing each day the corrupting and destructive influence of dark money, big money in our politics. At this point in our country's history, it is almost baked in that big money has a stranglehold on our so-called political branches, the executive branch, the Congress, the tremendous influence that these big corporate interests and billionaires have played. That is coming into stark relief now. But underappreciated for far too long is the extent to which these same forces have plotted a decades-long campaign to control and weaponize what is supposed to be the most independent branch, the federal judiciary. We are so thrilled to be with you here today, Lisa and I, with Court Accountability Action and Midas Touch Legal AF, with the person who is, I think, very clearly the single greatest champion in the fight against corrupting influence of big money in our politics and in our courts. The amazing senator from the great state of Rhode Island, Senator Sheldon Whitehouse. Senator Whitehouse, we are so thrilled to have you with us. Thank you for taking the time. We wanted to dig in on these swirling issues, on some issues happening in the Judicial Conference as a result of your oversight, as a result of your reform efforts in Congress, around Amicus lobbying, the lobbying of these big special interests through Amicus briefs, the flotillas you've described, and some real progress that we've seen. What got you sort of on the ball of these issues in the first place? How did you identify the extent to which these corrupting forces were making their way into these supposedly independent courts?
It actually began with work against the climate denial machine, and with not only being a lawyer, but being a lawyer who's argued in the Supreme Court, who's practiced as an appellate practitioner. And what I began to see were signs of distress in the appellate practice around the Supreme Court that weren't ordinary or normal. And a lot of the same names and players who I knew from the climate denial apparatus who were starting to show up. And if you looked for a little while, you began to see patterns emerge. And one of the patterns that I guess is going to be our topic today is, once you've got a captured court, and separate long saga how they captured the court, how do you tell it what you want on a reliable basis so that they all don't have to remember? And that's where this amicus rule comes in, because the way that the right-wing billionaires tell this captured court what it is that they want it to deliver is through flotillas of amicus front groups that they send in, groups, usually 10 or 12, on rare occasions, as many as 50. And so spotlighting that problem of the disclosure among these front groups who weren't telling anyone, not the court, not the other parties, that they were actually all connected, that they were actually funded by the same folks, in some cases shared offices. None of that was getting out, and it needed to get out. And so that's why I started pounding away on the complete inadequacy of amicus disclosure.
Yeah, Senator, it's such a joy to see you here on Midas Touch and Legal AF. And as you know, you're one of my heroes.
So mutual, Lisa. You're the star.
Well, it's just, I so appreciate how much time and energy you've devoted to really helping people understand what has happened to the U.S. Supreme Court and how we've gotten to this position where this right-wing flotilla of groups can basically predict or are signaling where the court should go. And for the most part, the Roberts Court is really following it. And I just would commend to our watchers, to the followers, to take a look at your speeches on the floor, that whole series that really lays this out. It's just super compelling. But I wanted to do a quick follow-up with you on this industry, in essence, this how, in some ways, how lucrative it is for these groups to be part of this this cottage industry, in essence, that has emerged around this captured Supreme Court.
Yeah, it's your work, Lisa, that shows that we're close to $600 million that has been spent by these forces out to capture the court that fund the majority of these front groups and that organize the flotillas of front groups that show up in court together, pretending not to be a concerted and coordinated effort. And, to an ordinary person listening to this, geez, $600 million, how could it be possibly worth it to spend that kind of money to capture the court? Well, just look at climate change. Yeah. The International Monetary Fund says that the effective subsidy from being able to pollute for free for fossil fuel in the United States is north of $600 billion a year. So if you can knock down President Obama's Clean Power Plan, if you can push the Supreme Court to limit regulatory authority over pollution, then even if you're saving 2% or 10% of that $600 billion, you're earning your $600 million back over and over and over again. The political influence operation of the fossil fuel industry is its most lucrative subsidiary, more so than pumping oil.
Yeah.
And the courts are just such a wonderful vehicle for these interests to use to advance these interests. Sort of as I mentioned at the top, in the political realm, people hate lobbying, they hate lobbyists, they understand how this all works. They punish electorally politicians who are too cozy with lobbyists. In the courts, there's, I think, still a widespread belief. I think that has changed dramatically in recent years, thanks to some incredible investigative reporting about the corruption and the outcome-oriented investment by these billionaires into these cases and into these justices themselves. But in the courts, you've got these amicus briefs. Nobody really knows what an amicus brief is. They can wrap up their ideas in doctrinal language that the justices and judges below them can, use like lawyers that people can't really access.
And by the way, that doctrinal language has been cooked up and grown in right-wing hothouses for the specific purpose of being a doctrine that gives the polluters the result that they want. So there's more to this than just sending in amici curiae, amicus briefs in little flotillas to tell the court what to do. There's actually a whole wing of the operation that is out building polluter-friendly and anti-regulatory doctrine for them to continue to echo, propagate until it sounds like it's actually a real doctrine and not something just cooked up for that specific purpose, made to order.
Yeah. And you can see it happening now, like the birthright citizenship case. They've got these, special interest connected scholars who are in the New York Times moving the Overton window to create common, public appetite for this kind of extremism. That
they did it with unitary executive. They did it with gun theory, Second Amendment theory. Yeah. They spend a lot of time cooking because this is a big deal for them until it's all properly cooked and done. And then they deliver it through the amicus curiae, like waiters delivering the meal from the kitchen. And the justices tend to lap it up, and the ones who lap it up the most are the ones who are on the receiving end of lifestyles of the rich and famous by the same creepy billionaires.
Yeah, it really is extraordinary. And it's interesting to see in the last few days, Justice Roberts speak up about this push for impeachment that's going on, being peddled by Donald Trump and Elon Musk in response to a temporary restraining order by a federal judge and an order that was issued from the bench that was flatly ignored by the administration. But at the same time, as you know, Senator Whitehouse, Chief Justice Roberts has been an obstacle for ethics reform, has been an obstacle in some ways in protecting the integrity of the judiciary, in my opinion. What are your thoughts on what Roberts said this week and also the broader context of the role that John Roberts has played in implementing this agenda, the agenda that Leonard Leo and these amicus groups and the climate and the industry trying to stop any efforts to mitigate climate change have been engaged in using the court to protect those financial interests?
Yeah, he's had a really ominous role in degrading American democracy, whether it was looking away from partisan gerrymandering where there was an easy solution and an easy constitutional argument, or letting not only unlimited money into politics from special interests, but then letting it become dark money, notwithstanding that was one of the preconditions of Citizens United, was that it had to be transparent, not to be corrupting. And on he went over and over again. The immunity decision. He has been at the epicenter of the destruction of American democratic guardrails. And so now I guess the question is, does he look at his work and does he look at this result under this really maniacal president and say, oh my God, I've gone too far, time to hit the brakes? And I think particularly this recent comment saying that impeachment is not appropriate was perhaps that. For sure, it was hearing informally from federal judges across the country, hey, you're the Chief Justice. We're getting clobbered out here in ways that are really wrong, that are really false, that bring really foul and nasty personal threats against us and our families, that are having to put people behind marshal service protection. And you're not going to say anything? You've got to speak up. So I think the pressure from the rest of the judiciary is what caused this in the short run, but let's hope it also causing some second thoughts about his campaign of destruction of democratic guardrails.
Yeah. And let's just hope that, if he does indeed try to hit those brakes, and I don't think there's any reason to think he will on some of these cases, the recent firing of FTC commissioners, the firing of an NLRB, National Relations board member, Labor Relations board member, that is part and parcel of the decades-long unitary executive attack. I think open questions about some of these really, really unprecedented, completely wild arguments being advanced by folks like Russ Vought on questions like impoundment, which is clearly going straight for Congress's power of the purse. But, with all of that erosion of the checks and balances of our democratic constitutional system, let's just hope that if he does try to hit those brakes, that the brake lines have not been cut and that there is actually a way to stop it.
Yeah, and I'd say that, there are a million elements to this, but two of them are, one is the stuff like, impoundment, birthright citizenship, that more or less goes straight to the Supreme Court and they've got a decision to make. And if they stay political, they'll make bad decisions. We'll see where that goes. The other is the ongoing litigation in federal court that is not on a speedway with a constitutional question to the Supreme Court. Violations of the Administrative Procedures Act, violations of personnel management policies, violations of civil law regarding defamation, things like that are very hard to get hyperlinked up to the Supreme Court. Things like that, I think, are going to be devastating to the Trump administration because they allow discovery. And once you get lawyers digging through the records behind the scenes, once you see that, for instance, what looked like contempt of a court order actually was contempt of a court order, that there are actually memos about it among the participants, then that all blows up. And there's a soft spot here with the lawyers who are engaging in these wrongful practices in front of courts. Because I'll tell you what, you can pardon a federal crime if you're president, but you can't get somebody their law license back if it's been yanked for improper practices before a court. And some of what the lawyers are doing, pushing these Trump cases, puts them into the boundary area of professional malpractice enough to pull their license.
Yeah. It's amazing to see some of these new political appointees taking these positions in court and acting actually with such contempt, like just in the tone of some of these pleadings by this Justice Department. It's just an extraordinary period we're in. And obviously it's daunting too. And I know you have a whole set of reforms, Senator Whitehouse, that you have been promoting. They can't pass with this Republican-dominated Senate, but I know you're still devoted to moving them forward. I wonder if you could share with us some of the most important reforms in this area that you think people should know about and we should continue to be building for broader public support for these vital reforms, because the integrity of our courts has really been diminished by this outside influence.
Well, the biggest legislative one is term limits for the Supreme Court. I recommend 18 years, and I also recommend making it retroactive because voters who want this now, it's very popular reform, shouldn't have to wait 18 years to find what they want to come into practice. What you don't need legislation for is a proper code of ethics for the Supreme Court. In all of the United States government, there are only 9 individuals who, when questioned about an ethics issue, don't have any neutral fact finding about what took place. And that is just wrong. And they can say, well, we're a Supreme Court, so it's different, but that's false.
Yeah.
Because 50 for 50, every single one of our state Supreme Courts has figured out how to deal with the supremacy argument or any separation of powers argument and has set up a proper independent fact-finding entity, whether it's other judges or a established panel of some kind, so that there's some fact-finding. And that's been the key problem with this court. There has been no fact-finding. We still don't know if Clarence Thomas paid taxes when that huge loan was forgiven, which is income and therefore taxable. We still don't know what he knew and when he knew it about his wife's activities in January 6th when he didn't recuse himself. We still don't know what was going through Alito's mind when he had that interview with a lawyer on a matter that was likely to come before the court and publicly took the side of the lawyer, who, by the way, happened to be his friend, and the client happened to be Leonard Leo, the guy who got him on the court when they knocked off Harriet Miers. So, I mean, the fact-finding would be really robust. And the fact that they don't do it is indefensible. And when something is indefensible, it's unsustainable. And then at some point it has to fall.
Yeah. And it's the fact of that reality is it seems to be a reflection of this mindset. I think this message that they very clearly sent last year throughout the oversight that you and your colleagues on the Finance Committee, on the Judiciary Committee were leading to get to the bottom of these issues, where they told the American people, they told you, we're on an island above the fray. You have no oversight authority over us. We're a separate branch of government, sort of ignoring altogether the basic idea of checks and balances, even as they have endorsed the importance of congressional oversight, the inherent oversight importance to the legislative function of Congress vis-a-vis the executive branch. Why should it be any different here? And interestingly, it's a little bit at play in this Amicus situation, where you sent a series of letters to Chief Justice Roberts, sort of pointed out, incrementally through all these examples, the ways in which parties and special interests were abusing this rule. And he said, there's nothing really we can do about it, but we're going to send it down to the lower courts and you can deal with them. Yeah.
So it's in the Judicial Conference right now. The one point I'd make to your observation about the supposed, independence of the courts here, the courts are supposed to be independent in their adjudicative role. When a judge is on the bench in his black robes in a case and is making a decision about an outcome in a case, that's adjudicative. Congress has nothing to say about that other than generally to set the ground rules for liability and so forth. But in terms of the actual outcome in the case, we have no business there, none whatsoever. However, when you're in the administrative side of the job, and ethics is on the administrative side of the job, Congress has every right to go into that in the same way that Congress has the right to set ethics rules for the executive branch of government. We can do that for the judicial branch of government as well, and particularly with respect to their financial disclosures, which is a statute that covers everyone. And what they've basically done is just cheated, at least at the Supreme Court level, by not doing the work of determining what the financial disclosure violation was, not treating it as if it's a political issue, something to be batted aside, rather than looking into what the actual facts are. So it took ProPublica and Lisa and other people doing this work about the Supreme Court to find out that behind these fake disclosure filings were these massive, inordinate gifts. And then that takes you into the Attorney General's office as another check, because the Attorney General gets to determine if it was willful or not, which makes sense because, first of all, you want that added check and balance, not judicial back scratching. And if you have failed to disclose on your judicial disclosures a huge gift of free income, you probably failed to disclose it on your taxes too. And you need an Attorney General who can look at those collateral crimes like tax fraud, filing false statements, and so forth. So there's a real logic to the way the system works, and it does not affect the independence of the court in its adjudicative function one bit.
Yeah, exactly. And, there's also the component of the congressional role in setting law, like the Voting Rights Act, reauthorizing the Voting Rights Act, and having a way to contend with a court and an opinion by John Roberts, as you mentioned earlier, to really cut back our voting rights, to use like a judicial fiat. And so I know you co-sponsored the No Kings Act in response to the unprecedented decision, the edict to give Donald Trump immunity retroactively and now, in essence, prospectively for so-called official acts. And that decision, really paved the way for his return. And I think in some ways emboldened him in this moment. And I wonder if you could speak to that. I know we're going to wrap up soon, but I wonder if you could talk about that a bit, Senator.
Yeah, that was a particularly appalling decision. And one of the things that you do when you're looking at constitutional questions is you look at what the Constitution says. And you also look at what it doesn't say.
Yeah.
And what the Constitution says is that if you're in my line of work, if you're a member of Congress, you actually do have immunity related to your legislative duties, the speech and debate clause. And you can't be required to answer anywhere else for what you say in your official legislative capacity, because the founding fathers were afraid that a violent executive with an army and police at his disposal could terrorize and work lawfare against the Congress, the Article 1 lead group. So they put that in. So there actually is immunity in the Constitution. And therefore, the fact that the president has no immunity is in direct contrast. They knew what they were doing when they wrote the Constitution. They looked at immunity. They gave it only to legislators. So that's one big hole in the argument that Roberts made. The second is there are exemptions even for Congress.
Yeah.
And the big one, of course, is treason.
Yeah.
When Roberts created a non-existent presidential immunity in that decision, he did not even carve out treason.
Yeah. Yeah. It's extraordinary. And I know I'm going to pass it back over to you, Alex, but, to have Chief Justice John Roberts swearing in Donald Trump to faithfully execute the law, when the essence of faithfully executing the law is to not break it, and then to see the sort of love fest at the State of the Union with,
thank you. I won't forget it.
Yeah, it's just extraordinary to see the times we're in. But back over to you, Alex, and thank you so much, Senator, for joining us.
Thank you, Lisa, for all your amazing work.
And Senator Whitehouse, thank you for joining us. Thank you for taking your work so seriously, for thinking so hard and deeply about these important questions, for truly manifesting the ideal of a constitutional officer on behalf of the people, for seeking accountability and protecting our democracy. We would love to have you back anytime. And until next time, signing out.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.